Hello and welcome to this FedSoc Forum webinar call. Today, April 21st, 2025, we're delighted to host a discussion on the weaponization of the DOJ, which is the second installment in our Theories of Presidential Power series of webinars, which is previewing the 13th Annual Executive Branch Review Conference, set to be held May 7th, 2025, at the Mayflower Hotel in Washington, D.C. Hope to see you all there. My name is Kayla Kleist, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, we will keep our introductions of our guests today brief, but if you'd like to know more, you can access their impressive full bios at fedsoc.org. Today, we are fortunate to have with us as our moderator, Stephen Domanovich, who currently serves as special counsel with Pillsbury, Winthrop, Shaw, and Pittman, where he is part of their litigation and white-collar and corporate investigations group. Prior to that, he served at the U.S. Department of Justice as an assistant United States attorney for the Southern District of Florida, and was also an assistant state attorney for Miami-Dade County. He helps appellate judges in Florida. He also serves as an adjunct professor at the University of Miami Law School in the Litigation Skills Program, and he volunteers as the co-president of the Miami Lawyers chapter of the Federalist Society, and also serves on the executive committee for the Criminal Law and Procedure Practice Group. And I'll leave it there, as well as leave it to him to introduce our panel. A last note before I get off your screens, if you have any questions throughout the program, please do submit those via the question and answer feature, likely found at the bottom of your Zoom screen, so they'll be accessible when we get to that portion of today's webinar. I'll ask that all questions there, A, pertain to this discussion, and B, end with a question mark. With that, thank you all for joining us today. Mr. Domanovich, the floor is yours.
Thank you very much, Kayla, and welcome everybody. Thank you so much for being here on an early Monday morning. We have a very robust turnout for a fantastic topic. As Kayla was mentioning, this is our panel discussion today, where we will discuss the DOJ and claims that it has been weaponized. The panel discussion, again, as Kayla mentioned, is part of our Federalist Society's Theories of Presidential Power series, which will culminate in our Executive Branch Review Conference that's set for May 7th at the Mayflower in DC. And as Kayla mentioned, my name is Stephen Domanovich, and I'll be your moderator for today's panel. I thank Federalist Society for their kind offering me as a professor. I'm a litigation skills professor at the University of Miami, but I am a practitioner at heart, as Kayla mentioned in my bio. But thank you for that brief accolade. But today's topic, again, to introduce, is extremely important for us as lawyers and as citizens who have either worked with DOJ, in DOJ, or have frequent contact with DOJ in our cases. This will confront a widely held view about the weaponization of DOJ, if in fact it's, something like that has happened, and also offer a broader perspective on the topic across not just this window in time in the current social and political climate, but also across previous administrations, and offer somewhat of a historical context, and to offer more of a 360 view and a larger historical context and framework to the current landscape. And to that end, we have two distinguished panelists amongst us today, who will no doubt offer very different and varied viewpoints on the topic in the spirit of a true and robust Federalist debate. And without further ado, I'll first go alphabetically, and I'll introduce Mr. Brendan Ballou. Brendan Ballou is a former federal prosecutor and served as special counsel for private equity in the Justice Department's Antitrust Division. For 2 years, he prosecuted cases involving the incidents that arose out of the incidents at the Capitol on January 6th of 2021. He began his career at the Justice Department in its National Security Division, where he advised the White House on counterterrorism and other policies. And he's the author of the book, Plunder: Private Equity's Plan to Pillage America, and his work has appeared in the New York Times, State, Politico, The Atlantic, and The Nation. I'll then turn to our second panelist today, Mr. John Laurel. Mr. Laurel is a trial lawyer with over 30 years experience, specializing in complex civil and criminal litigation, and he successfully represented high-level executives charged with complex white-collar crimes and accused of civil wrongdoing. He graduated from Georgetown University Law Center, where he was an editor of the Georgetown Law Review. He joined the criminal division of the United States Attorney's Office for the Eastern District of New York and subsequently founded a boutique trial firm which maintains a national practice on the representation of business executives. He is a fellow of the American College of Trial Lawyers and a graduate of the Jerry Spence Trial Lawyers College. And most recently, he successfully represented President Trump as trial counsel in the criminal case brought by the DOJ special prosecutor in Washington, D.C. So to our panelists, welcome, and thank you so much for joining us today for what I have no doubt will be a very thorough and robust discussion about this very important topic. Just to give you an outline for our format today and to provide a scaffolding of our discussion, we'll begin with opening statements from each of our panelists, which will be about 4 to 7 minutes. That will be followed by a moderated discussion, which has about 6 topical questions that really dive into the heart of this particular topic area. That'll be followed by a question and answer session to last about 15 minutes or so. And then we will conclude around 11:50, 11:55 with closing remarks from both of our panelists. So again, thank you again for joining us today. And it's my honor and privilege to be a moderator for this discussion. I'll now start with just alphabetically. I'll begin with Mr. Balu to offer his opening statement, followed by Mr. Lauro.
Great. Well, Stephen, thank you so much. And I appreciate the opportunity to be here. As more of an ACS guy, I appreciate FedSoc's extension of the olive branch and a chance to have a dialogue here. Yeah. So let me talk a little bit about the weaponization that we're currently seeing at the Justice Department and why it's unique. So President Trump is weaponizing law enforcement in ways that I think have been very prominent and in ways that this administration has been very eager to talk about, but also in ways that it has been less eager to talk about. The ones that are prominent are the ones that you know. The decision to ignore court orders regarding the deporting of Juan Abrego Garcia, refusing to facilitate his return, and refusing to provide information to the court about what efforts it's taking to do so. It includes directing the Justice Department to investigate political enemies of the president, like Christopher Krebs and Miles Taylor. And it involves the decision to dismantle the Consumer Financial Protection Bureau in violation of a court order. These are things that the administration is pretty happy to talk about. But at the same time, there are things that this administration has been pretty quiet about, but have been arguably just as important. It includes stopping enforcement of the Foreign Corrupt Practices Act and criminal enforcement of the Foreign Agents Registration Act, which prohibits acting as an unregistered agent of a foreign power. It involves dismantling the public integrity section and the criminal section of the antitrust division, which go after corrupt politicians and price fixing, respectively. And it involves disbanding the Klepto Capture Task Force and the National Security Division's Corporate Enforcement Unit, all of which go after international oligarchs. In other words, the administration is dismantling the infrastructure for going after rich criminals. Now, these actions tend to be defended not on their merits, but by the argument that previous administrations were just as bad by both Democrats and Republicans. You can look to Democrats and point to pardons in the Clinton administration or the Wilson administration's decision to deport dissident immigrants without due process. You can point to Republican administrations, whether it's the abuses of President Nixon or George H.W. Bush offering clemency to avoid being implicated in Iran-Contra. You can name any number of other examples. But I think ignoring the present by focusing on the past is a mistake for a very simple reason. Whenever presidents in the past have misused law enforcement, they've at least stated a commitment to democracy and to the rule of law. That's not the case here. The reason that this is different is that this president has both said and shown that he won't follow court orders that he doesn't like, and he won't accept election results that he doesn't like. He said that he wants to be dictator for a day and that he's exploring seeking a third term. And most obviously, President Trump aspired to overturn the results of the 2020 election. Now, John and I probably will have a very strong disagreement about whether or not that was criminal, but I think it's undisputed that he tried to stop the election certification. What this means is that the weaponization that we're seeing today isn't just the flaws of an imperfect democratic system, but an attempt to end that system altogether. And there's international examples of this happening elsewhere. You can look at the stories of Brazil and Argentina and Chile in the 1970s and 1980s, and all the tactics that we're seeing now over the past 90 days are tactics that we saw in those countries. So I encourage you all to stay focused on the present, to confront the problems that we face now. And I ask you to do that because the Federalist Society has unique authority in conservative circles. You have a lot of influence. And so I encourage you not just to underestimate your own responsibility, but your own power in fighting this weaponization and this move towards illiberal government. And I'm excited to be here. Thank you.
Thank you very much, Mr. Ballo. Mr. Lara, please offer your opening statement.
Yes, first of all, thanks everyone for being here. I come not as a pundit or an observer or someone making political statements. I come as a practitioner who was in the front line of the politicalization and weaponization of the Department of Justice by the Biden administration that actually created a very significant constitutional crisis in our country by deciding to use the power of the Department of Justice and the criminal law to go after and neutralize not just a political opponent, but a political campaign as well as a political movement. In November 2022, Joe Biden said that he would do everything possible to prevent Donald Trump from becoming president. And what he decided to do is use the tools of the criminal justice system in order to accomplish that goal. That has never been done before in American history, and hopefully will never be done again. It was an extraordinary exercise of left-wing authoritarian power, coordinated not just in the Department of Justice, but also with other state and local political figures to engage in what we now know as unconstitutional lawfare. It was quite extraordinary. And unfortunately, there was very little criticism from the national news media, from legal elites, from the academy, law schools. But most importantly, there was no criticism at all from the Department of Justice. In fact, the Department of Justice decided, I think, unfortunately, to become directly involved in that politicalization and carry out the goals of what Joe Biden had decided to do, which was to neutralize President Trump's candidacy. I can only speak to what I saw in the January 6th case, which was a sham prosecution. I had access to 14 million pages of documents. I looked at grand jury testimony. I had access to highly confidential information. And it was a prosecution that was politically motivated. It was intended to do one purpose, which was to keep Donald Trump from becoming president. And it unbelievably backfired on those with political motivation, since the American people saw through what was happening. And I think in many respects were repulsed by it. The American people were able to see firsthand the damage to our constitutional order, to our democracy, by an authoritarian government led by Joe Biden and carried out by the Department of Justice that engaged in this kind of activity. It was a wholesale denial of due process. When President Trump was indicted, I had the opportunity to present to the court a request that he have time to get ready for the trial. The response from the government was, well, 90 days or 120 days would be well enough in a case with 14 million documents and over 500 identified witnesses. There was simply one purpose by the department, which was to do whatever was possible to achieve a political end. What happened to President Trump, what happened in the Washington, D.C. case, is nothing short of an outrage. It should never happen again in our democracy. We were blessed by the votes of the American people that rectified an out-of-control Department of Justice. And what was shocking to me is no one, not one person in the department stood up during that period of time and said it was wrong. At the end, in fact, Joe Biden criticized his own department in pardoning family members by characterizing his own Department of Justice as weaponized and politicized, even though over the last 4 years, he did everything he could to use those tools in order to stop a political opponent. So how did we get here? The only way we can understand how we got here is by knowing from where we came. And what the present administration has done, and Attorney General Bondi has made it very clear, is a retrenchment from that weaponization. So we now see no political prosecutions, no sham indictments, no fake grand jury proceedings, but instead a way of looking at the Department of Justice in terms of restoration and ensuring that the rule of law will be carried out going forward. There are certainly going to be areas of disagreement. The courts are dealing with those issues. Joe Biden proudly said that he found a way to get around the Supreme Court ruling regarding issues of dealing with student loans. More recently, the Supreme Court issued an order halting the deportation of immigrants who are here unlawfully. And of course, that order has been honored completely. So what we're dealing with, I think, going forward is an understanding what took place in the past and making sure that the abuses under the Biden administration never happen in this republic again.
Thank you, John. We'll now launch into the substantive part of the discussion and thank both panelists for their intro statements. Now we'll get into the heart of the discussion and begin with our substantive questions and topics. The first, and I'll alternate between both of our panelists, so you'll have an initial shot at the first answer back and forth. So I'll begin with Mr. Ballew, our first question, and that's, what does it mean to say, or when folks have said that the Department of Justice has in fact been weaponized?
Sure. Well, I think you can mean at least two things. One is where the Department of Justice breaks the law, disobeys court orders, breaks rules of professional conduct in investigations or prosecutions, or using law enforcement legally, but to favor friends and punish enemies for unrelated personal or political examples. Let me give you just a few examples. So, right now what we're watching in the DC U.S. Attorney's Office is that the interim DC U.S. Attorney has announced investigations into Chuck Schumer, into Eugene Vindman, into Georgetown University Law Center, and into various medical journals. And all three of us on this call are former prosecutors. And I think we all know you generally don't talk about or announce investigations ahead of time because it violates Rule 3.8 and heightens condemnation against the accused. So that's an example of breaking a rule of professional responsibility to essentially target political enemies. That's happening right now. But there are also ways that the administration right now is potentially behaving legally, but still using law enforcement to favor friends and punish enemies. Right now we're seeing the Securities and Exchange Commission drop investigations into Justin Soon after he essentially paid the president $50 million. Now, again, John is I really respect John as a lawyer. He is a real lawyer, not a TV lawyer. So I appreciate his comments here. But he did exactly the move which I was talking about, which is rather than focusing on these abuses that we're experiencing right now, he's pivoted to the past. And the concern that I've got is whether that is intentional or not, we end up becoming apologists for an illiberal movement. And this is a playbook that we have seen many times before in Chile, in Argentina, in Brazil, in Spain, and elsewhere, where essentially the administration uses law enforcement to try to diminish the power of outside voices and outside institutions. And if we're not honest about what's happening right now, it's only going to continue, and it's only going to get much worse. We are less than 100 days into this administration, and already they are ignoring court orders.
Now, Mr. Lara, I'll turn to you with the same question. What does it mean to say that DOJ has been weaponized, and how do you respond to Mr. Ballew's comment that you're pivoting to the past and engaging in apologetics in your position?
Well, in order to understand the issue of politicalization, we have to also recognize when it occurs. Of course, those on the left want to ignore what happened in the past. And I think it does a great disservice to the discussion that we need to have. And we need to have to recognize what actually happened during the Biden administration and the terrible damage that it did to our Constitution. It's impossible to ignore that. And the reality is that the weaponization has been a series of ongoing activities over the last 4 years that have put all of our constitutional rights in danger. And it wasn't just against President Trump, it was against a political movement. So you saw the FBI targeting religious Catholics under Biden. You saw the FBI going into school board meetings. You saw other examples of denial of due process. So in order to really address this issue, we have to look at it in its totality. And I think it's disingenuous to say, oh, it's never happened before, or, let's put our head in the sand and ignore it. There's never, ever been anything like the political prosecution of an opponent. To talk about Venezuela or talk about Cuba or to talk about other authoritarian countries, that's where it happens. And yet those on the left completely ignore that reality. The prosecutions against President Trump were unjustified. They were used simply for political purposes. They should have never happened, and it should never happen again. And I think if we ignore it, then we do so at our own peril. And to give you just one example, everything that was done in the Washington, D.C. case by the Department of Justice was done to embarrass a political candidate, whether it was trying to go to trial quickly, whether it was hiding Brady material, whether it was making public statements about the case, whether it was rushing to judgment before the Supreme Court. And sadly, not one person in the Department of Justice stood up and said that was wrong. What that tells me is that the values in the department were seriously compromised. And that has to change, and that's what the current administration is addressing.
Absolutely. And that kind of dovetails into our next kind of topical area. And that's really, to what extent do you believe that the Department of Justice itself is meant to be independent of the president? And where do those boundaries, if any, begin and end for you, John?
Well, that's a good question because I think there has been this sense that somehow prosecutors have their own sovereign jurisdiction. In fact, the Southern District of New York is referred to as the Sovereign District of New York. That simply doesn't exist in a unitary executive. Everybody who works in the executive works for the president, and the president has authority to issue public policy proclamations, many of which my friend Brendan obviously politically disagrees with. But that's the function of an executive. As one person once said, elections have consequences. President Trump won the election in November 2024, and he's entitled to carry out his political mandate. And those in the Department of Justice need to recognize that. And if they're not comfortable representing the president and the government in connection with those responsibilities, and they simply should look for other employment, because that's a function of the executive branch.
Absolutely. And, I refer probably to Federalist 70, where they said that the executive should be a singular, energetic executive that will act decisively in times of crisis and also execute the laws. So, Mr. Ballo, I turn to you with that. So, what's your response to that, to the question of the extent that the DOJ is meant to be independent of the president, and where do those boundaries begin and end?
Yeah, and I'm happy to talk about that. To back up one sec, John made this point that I'm arguing that abuses of the Justice Department haven't happened before. No, they absolutely have. I say that in the opening statement. One of the most shameful sort of abuses of power that we had occurred under a Democrat, which was the Palmer raids under Woodrow Wilson, when they deported dissident immigrants without due process. I think that was a black mark on the nascent Bureau of Investigation and on the Justice Department. You see examples like COINTELPRO, which occurred under both Democrats and Republicans, from Eisenhower to Kennedy to Johnson to Nixon, of surveilling political opponents. Again, very much a black mark on the Justice Department's history. But the key difference here is that all of those presidents had at least a stated commitment to the rule of law and to the democratic process, and that hasn't happened here. President Trump seems to only support democratic elections when he wins, and to support only elections when you win is to not support democracy at all. John made this very good point in transitions. Stephen, I want to answer your question. He said this line that stuck with me, that courts are dealing with these issues. They certainly are. They're certainly issuing orders, but this White House has made clear that for the orders it disagrees with, at least in some cases, it doesn't plan to follow them. And so what that means is the stakes of abuses in this moment are so much higher than they have been in the past, because these are not the excesses of a flawed but functioning democracy, but an effort to change that democracy into a more illiberal movement. And that goes into the answer to your question, which I think is a very good one, which is, to what extent is the Justice Department meant to be independent of the president? Where do those boundaries begin and end? You know, after the Nixon administration, Edward Levi, under a Republican president, instituted a number of reforms to try to put some political distance between the Department of Justice and the White House. And there were a lot of very specific reforms. I might phrase it as the general idea that while the president can choose prosecutorial priorities, they can't choose people to specifically investigate and prosecute. And I'll say, even if you're a supporter of a unitary executive theory, that sort of separation isn't just good for the people, it's also good for the president, because the only thing that the Department of Justice has is its credibility. And if prosecutions are seen as politically motivated, when you have a White House issuing an executive order to investigate Christopher Krebs or Miles Taylor, or whoever it happens to be, any subsequent investigation or prosecution, whether or not it's meritorious, will be seen as politically motivated. And so it ultimately hurts the executive branch to be too politically intertwined with the Department of Justice. And let me just add one more point about that.
Yeah.
Regulations can only mean so much in the Department of Justice. Regulations can be changed, they can be ignored. But as a practical matter, the way that the Justice Department has had some institutional separation from the political branches is three things. One is grand juries and trial juries to check the ambitions of prosecutors. The other is courts to obviously make sure that due process is being followed. And then the third is professional obligations to bar associations and lawyers' independent oaths to uphold the Constitution when they join the Justice Department, an oath that all three of us have taken at various points. The challenge that we've got now is that all three of those external checks are under threat. The DC U.S. Attorney's Office, for instance, is circumventing the grand jury process by announcing investigations and issuing requests for documents without actually going to the grand juries to get subpoenas. The Trump administration is ignoring court orders around Mr. Abrego Garcia. And one of the things that most concerns me is that they are announcing investigations into bar associations. And when you look at the history of countries like Brazil and Argentina and Spain that have gone through periods of illiberalism, one of the places that these governments go after the hardest are bar associations, because they can be an independent source of authority and advocates for the rule of law. And so it's highly concerning to me that we are now seeing that same sort of pressure applied here in the United States.
And there's kind of a lot to unpack right there. So I'll just allow John maybe a 1 to 2 minute response to all that. I mean, John, what do you have to say?
I kind of chuckled to myself because over the last 4 years, the Biden supporters went after lawyers tooth and nail at bar associations and tried to get them disbarred and sued them and used all the resources to go after lawyers. So that's quite interesting. But I can't think of a single order that the Trump administration has said it's not going to obey. I mean, it's one thing to say in sort of political argument that that's happening, but it's not happened. And no court has found that the Trump administration violated any order. And I think President Trump has repeatedly said that he intends to obey the law. There's arguments that people make. That's what we do all the time, and they're fought out in the courts. I would also say that the courts have an obligation to stay in their judicial Article III lane and not get involved in extraneous matters like foreign policy. So I think in terms of institutional norms, both an executive and the court system need to pay attention to the constitutional roles that they play.
Absolutely.
Stephen, can I just respond to that very briefly?
You can have 30 seconds.
Okay. So, John said that there haven't been any, if I don't want to misstate his argument that court orders haven't been disobeyed. There are at least 3 so far on the Abrego Garcia case alone. So one is Judge Boasberg's order in DDC demanding that the flights not take place and deliver the undocumented immigrants to the CCOT facility. There's Judge Shinnis's order in the District of Maryland to provide daily updates on the effort to facilitate Mr. Abrego's return. And then obviously the Supreme Court's order that it should facilitate his return, after which the White House posted a tweet saying that they would never do so. So we have at least 3 instances in that case alone, not to mention the civil cases, such as what's going on at the Consumer Financial Protection Bureau. And again, I just want to point out the argumentation shift that's going on here, which is I'm trying to keep folks focused on the present attack on our justice system and the trend towards a liberalism that we're experiencing. And the defense tends not to be that it is okay to ignore court orders, but to try to refocus the argument back towards the past and say that that was just as bad, if not worse. And I think whether intentional or not, that minimizes the illiberal moment that we're experiencing.
All right, John, if you'd like just a brief response to that, and then I'll turn to
Yeah,
Brendan.
I mean, the one order was after the plane had taken off and gone to Central America, and then the order was, I think, to try to get it to come back. I mean, there has to be some kind of common sense applied here. And the other thing is, the question of deportation of folks that engage in terrorist activities in the United States or gang activities in the United States is principally one that is vested in the president and Article 2. So all I would say is there's not been one finding by a court of law that there's been a violation of any court order intentionally by the Trump administration. And I think it's just inaccurate to suggest otherwise.
Can I just issue one correction there, which is Judge Boasberg did find that there was probable cause to begin contempt investigations for the violation of his order. So there has been at least one court order finding that.
And that was frozen by the Fourth Circuit, as I recall. And nothing.
So the Fourth Circuit decision was Judge Wilkinson's decision, which was obviously pretty evocative, where he was saying that, in fact, the administration was in violation of administrative procedures for beginning these deportations without due process. And I'll just say, I agree that, foreign policy really is the province of the executive branch. But to, paraphrase Judge Wilkinson, who was, I believe, appointed by President Reagan, a very conservative judge, if the administration truly believes that Mr. Abrego Garcia is a member of MS-13, then it should have all the confidence in the world to follow legal due process and prove that fact. To do otherwise undermines our system of justice.
All right,
I think we're talking about 2 different cases, though, because the criminal contempt case is the one that was stayed by the Fourth Circuit, and that was not the Wilkinson opinion. I could be wrong, but that's not my recollection.
Well, in the spirit of that, I think we've kind of there's a lot of there. But in any event, there's certainly a robust fodder for additional explication for that. But I'd like to maybe shift and maybe now that we've talked about the DOJ in essence and its independence and the president's agenda and his role, now shifting to more of what do you make of AG Bondi's task force? This also dovetails into what you were kind of saying and President Trump's executive order. Are these genuine efforts to restore the trust, or as some may have wrongly think that it would be a media stunt or a political theater, as some on the left have said. So what are your thoughts and opinions on that? And I'll start with Brendan.
Yeah, well, so the memo directs the investigation of those who prosecuted the president and the January 6 rioters. And obviously, for 2 years, I was involved in prosecuting rioters who attacked the Capitol, attacked police officers. So obviously, this is somewhat personal for me in that many of my colleagues have been fired, others demoted, others have been doxxed, others have had their lives threatened. But putting emotions to the side for a second, I think it's important to step back and see how an order like this fits into a broader pattern. Illiberal governments typically try to rewrite the violent origin stories of their creation. That's why you see President Milei in Argentina and President Bolsonaro in Brazil start to praise their dictatorships rather than speaking the truth about their human rights violations. An enormous number of politicians' careers now depend on ignoring the fact that thousands of people tried to overrun the Capitol and stop the certification of the election. And by demonizing the prosecution of January 6 rioters, this is an attempt to justify those rioters' pardons. And again, I think a little bit of international context here is helpful, is that countries often try, illiberal countries, I should say, often try to form sort of vigilante and militia groups that are allied to the head of state, but ultimately unaccountable to the government. And this can exist along a spectrum from, Iran to Colombia. And that's what's happened here, which is we now have over 1,500 people who have been placed essentially beyond the reach of the law by the president, many of whom have said that they plan to seek revenge, some of whom have said that they plan to buy guns, some of whom have already been arrested or who have died in shootouts with the police. I think that most people concede that we don't want to have militias or vigilantes in America and are reluctant to acknowledge that that is the likely effect of these pardons. And so demonizing the prosecution of the January 6 rioters is a way to excuse what's been created.
Now, Mr. Lard, do you agree with that? And to what extent do you believe the task force is? What do you believe the role of that is? And President Trump's orders, and do you have alternate opinions as to what Mr. Ballo was saying regarding within the context of the international community and what's going on with other governments?
Yeah, it's interesting. When I was preparing for the potential Trump trial, I talked to lawyers from Venezuela and from Cuba to try to get an understanding of what do you do when you're facing an authoritarian left-wing government that's trying to put a client in jail and using the criminal justice process, and when traditional illegal elites are silent and not objecting, and instead really facilitating that kind of activity. So I think what Attorney General Bondi is doing is really trying to readjust the proper goal and the proper objectives of the Department of Justice. It's not just focused on the abuses by prosecutors in the January 6 prosecutions, but it's also focused more widely on the proper role of the Department of Justice not to engage in political activities and not to use the department's weapons for political purposes. There were clearly incredible abuses going on in the J6 prosecutions that need to be addressed. But more fundamentally, the Department of Justice had been used over the last 4 years to destroy a political movement, whether you call it, the garbage of America, as Joe Biden did, or deplorables as Hillary Clinton did. The reality is that the Department of Justice was used to in effect, marginalize a political movement. And that has grave consequences for America more generally. But what Attorney General Bondi has done is said, let's take a look at this issue more broadly, not just in the context of the J6 prosecutorial abuses, But more generally, in terms of the proper role of the Department of Justice, I think that's a very healthy recognition of how the department should run. And sadly, that wasn't done under the Biden administration. What's so ironic to me is upon leaving, Joe Biden described his own Department of Justice as being weaponized and politicized. And he used that as a basis to pardon family members who had engaged in corruption and bribery that could have potentially led to criminal prosecutions of him as well. So in order to really, understand the Attorney General's order, I think we have to look at the restoration of values and the rule of law in the Department of Justice, which is now taking place. And it's a clear goal of the administration. I know that because I participated in the transition, and these issues are taken very seriously.
Absolutely. And that just goes into our next question. And I want to leave time for some questions and answers asked. But John, what reforms do you think should be implemented to safeguard DOJ independence? And what can be done in the future to restore public confidence?
It's a very good question and a difficult one. I think that unfortunately and sadly, folks in the DOJ and who served in the DOJ and former prosecutors no longer have shared values in terms of what our system should look like and how our system should operate. I received enormous blowback and personal criticism from former prosecutors who objected to the fact that I represented President Trump and objected to the rule of law and fundamental due process. But I think the only way that we're going to get back on track is if lawyers from all political persuasions understand the true constitutional role that we play and understand the importance of the Department of Justice in carrying out that role and strict adherence to the Constitution. I think that's the only way that we're going to get this discussion and this policy back on track. But it's a serious issue that requires a lot of attention. And I know that Attorney General Bondi, who I've been friends with for 30 years, is deeply committed to that. And I think it's essential for our future that be carried out.
Absolutely. And Mr. Ballo, your response as well. Which reform should be implemented, if any, and what can be done to restore the public confidence?
Yeah. So there's obviously a role for courts to play here in putting some practical limits on the pardon power and recognizing their limit into scope and also into the motivations for pardons. Judges obviously need to aggressively inquire into the selective prosecutions that are presumably coming because they've been directed through executive orders. But I really, given that we're talking to the Federalist, I really wouldn't forget about the power of professional associations to exert soft power and bring out the best of institutions like the Justice Department. So again, in illiberal countries, in Chile, in Brazil, in Spain, there were frequent attacks against the bar associations because they were able to stand up and provide an independent source of authority when the rule of law was being attacked. Sometimes those bar associations stood up, sometimes they didn't. Obviously, it's very concerning to me that the White House has directed investigations into state bar associations because it fits into this broader illiberal pattern. But I will say, given FedSoc's credibility and standing within the conservative legal community, I think you all can play a really important role here in helping to make sure that the rule of law survives. So, I really encourage you to call out abuses of power in print, in social media, at events, to join litigations when independent institutions are under attack. I'm sure you've got a lot of Harvard graduates right now. I'm sure this would be a great time to support your alma mater. I'm sure a lot of you are married to doctors and so forth. The U.S. Attorney's Office has begun investigations into various medical journals. Now would be the time to stand up for those things. I encourage you to just do the things that you will feel proud of in 20 years and not underestimate your importance here. But what I find concerning is that thus far in this conversation, I haven't heard a single defense of President Trump's decision to ignore court orders, to dismantle various arms of white-collar law enforcement, to direct prosecutions against specific people. The response repeatedly has been, well, somebody else did it first. And whether that's intentional or not, we minimize the danger of the moment when the person doing this has said that he doesn't respect court orders and doesn't respect the democratic process. So the stakes
All
are
right.
very high here, but also so is your power.
So I'll allow Mr. Laro to respond to that for 2 minutes before we go to a question and answer, because I think there's a lot in terms of what your allegations are in terms of the bar associations and also the alleged not following of court orders. So Mr. Laro, if you'd like to conclude with a minute or two on that before we go to our question and answer.
Well, what was very sad to me is when President Trump was being denied due process, none of the bar associations stood up. None of the bar associations weighed in. None of the federal prosecutors who are now virtue signaling to one another did anything in terms of objecting to the diminution of the rule of law or the denial of due process. So I think in terms of being proud, I think it's everybody's responsibility to stand up and fight for justice. I certainly did that in defending President Trump at great personal risk. But the bottom line is that we all have to do what's required. But for one side or the other to simply ignore the reality of the importance of the Constitution and following the rule of law, I think is particularly dangerous for our ability as a country to continue to follow in the traditions of our Constitution. And that, to me, is the most important part of everything that we have to do at this point.
Thank you so much, John. And now I'll turn to our question and answers before I conclude with some closing remarks from both of our panelists. Our first question is, Mr. Laro, you said that you saw this begin in the Biden administration. Did this not start in the Obama administration, as demonstrated by the Operation Choke Point, where the White House and AG worked together to issue a plethora of subpoenas to banks under FIRA? The legislator determined the DOJ illegally issued subpoenas solely for the purpose of targeting industry that administration didn't like in order to pressure the banks to sever ties and not allow certain legal industries to have access to the banking system by tying them to illegal industries. While the president was targeted this time, industries targeted before by Obama and Holder, has this not undermined the credibility of the DOJ, and what can be done about it?
I think it has, and I was speaking more in terms of my own experience in dealing with the weaponization during the Biden administration. But what is fascinating to me is that when the left engages in this activity, there's complete silence in the legal community. There's complete silence in academia. There's complete silence in the news media. And as a result, what we've seen over a long period of time under Obama and Biden is the diminution in the rule of law. And I think the only way that it can be addressed is by what I think Attorney General Bondi is doing, which is having a full-scale understanding and analysis and review of the process that goes on in the Department of Justice to ensure that the rule of law is followed. I think everybody, if you want to feel good about yourself on the left or the right, should applaud that effort instead of trying to demonize what the administration is doing currently.
Another question that we have is, what effect, if any, do you think that threats of DOJ to dismantle parts of the DOJ, for example, probationary employees, certain sections like ENRD, may affect the implementation of rule of law at the line attorney level? And
yeah, I can take this one, at least to start. So, it's something that I obviously saw up close when interim U.S. Attorney Ed Martin fired all of the probationary attorneys who worked on January 6th prosecutions. Now, after the election, obviously the prosecutions of January 6th rioters ended, and those attorneys were reassigned to different sections, such as the Superior Court section, which prosecutes DC street crime. Those folks were fired, which meant that there were fewer lawyers to take on exactly that sort of work. The challenge that we've got is that DOJ and the administration in general seems to be interested in cuts into very specific parts of the Department of Justice, with namely those parts that go after white-collar criminals. And so, we're starting to see that in antitrust. We have seen that in the public integrity section. And so my concern here is that essentially at the federal level, there's going to be very little enforcement of the criminal laws against the very rich while we continue to prosecute the very poor. And a system where we only go after the folks that don't have a lot of money really is not a functioning system of justice. So I'm very concerned about that.
Mr. Laurel, do you have any comments on the effect and the threats, alleged threats of DOJ to dismantle the parts of the DOJ?
Yeah, let me just say, I think the world and have enormous respect for Brendan, but he's a passionate political advocate. And no doubt he brought that passionate political advocacy to the prosecution of J6 people and others. And that kind of passionate political advocacy comes with a lot of implicit bias. And what we saw, and this is not directed at him individually, what we saw in the transition in the Department of Justice is many politically motivated prosecutors, DOJ folks, who are going to take a very aggressive position to try to undermine the administration as in terms of its goals. And the president is entitled, I think, to have a Department of Justice that supports his positions and supports his objectives. I think that's critically important. But in terms of the overall running of the department, I think there has to be a commitment to following the Constitution and following the rule of law. And that has to be top down. That's coming from the Attorney General all the way down to the line prosecutors. What efforts are made to try to reduce government waste, I think are healthy for us all. I think the Department of Justice certainly could use that kind of review, but I don't think it's going to affect the line prosecutors. The examples that have been used is policy issues. Well, we should be doing more to prosecute antitrust cases. We should be doing more to prosecute white-collar crime. Those are all policy questions, just as it was when the Biden administration refused to prosecute illegal immigration and allowed 10 million non-citizens to flood the United States against the rule of law, completely ignoring every semblance of the rule of law. And not one Department of Justice official during that period of time stood up and said, that's wrong. We took an oath to obey the law.
Absolutely. And this kind of dovetails on that as well. So, Mr. Ballo, this is a question. Why was there a decision from the DOJ regarding the prosecution of those who committed crimes during the BLM riots that were similar to what happened on January 6th?
Yeah, so there were prosecutions of people involved in BLM and other riots during the summer of 2020. I might be getting my numbers wrong, but I believe the AP reported that there were 120 prosecutions and that the average prison sentence was actually significantly longer than those who were convicted or pled in January 6 cases. So there was an aggressive prosecution that resulted actually in tougher punishments than for the average January 6 rioter. I will say, again, all three of us are former prosecutors. One of the basic challenges that the Justice Department had in prosecuting riots from that summer is that most of the folks that were engaged in that didn't bring their cell phones and didn't share about it on social media. The challenge is that, the thing that happened on January 6 is tons of folks filmed their activity and bragged about it on social media. And I'll just say to that point, I interviewed a lot of officers that worked at the Capitol that day, several of whom thought that they were going to die that day. They texted their families they weren't expecting to get out. One of the comments that stuck with me with those interviews is one said, I worked a lot of riots over the years. But what made January 6th different is that these folks thought that they were right. They thought that they could flout the rule of law without consequence. And the challenge that we've got now is that the pardons of 1,500 rioters, including rioters who assaulted over 140 police officers, have been proven exactly right in that regard.
Okay. And just to, as we kind of edge up on the close of the hour, just offer about 2 minutes from each panelist regarding closing statements on the topic of the purported weaponization of the DOJ, and what can we do going forward as your final, closing remarks for the panel. And I'll start with Mr. Ballo, and then conclude with Mr. Laurel.
Yeah, I'll just restate the reason that I came here is because I think the Federalist Society has enormous power and influence at this moment. You guys bring unique credibility to this administration. And in the course of this hour, we have not heard a single defense of this administration's decisions to name investigations of specific political opponents, its decisions to ignore court orders around the CFPB, its decisions to essentially try to rewrite the history of the attack on the Capitol. What we've heard instead is an argument that other folks have done this too. I think the decision to do that, the attempt to minimize the present by focusing on the past, is a mistake. And so I hope that you recognize your power to shape history here, and I hope that you act on it. Thank you.
Mr. Laurel, final concluding comments.
Yeah, I think what Brendan certainly articulated was what I saw in the Department of Justice over the last 4 years, which was very highly politicized lawyers who wanted to use the department to achieve political purposes and political ends, and recognized that they had enormous power to do that, whether it was in the context of arresting peaceful trespassers in J6 or going after the President of the United States to prevent him from campaigning. But I think the only way that this gets turned around is if people in positions of authority in the department act in accordance with the Constitution and the statutes and do what's necessary to ensure that the rule of law is followed. And I believe that's going to happen. I also think that, unfortunately, in our legal institutions, in the legal press, among a lot of bar groups and organizations, it is so skewed in one direction, where there's no longer any kind of degree of discussion or dialogue such as we have here. And talking about the Federalist Society is probably the only place where you can get this kind of dialogue, because you certainly don't get it in other organizations around the country. But I think the more we talk, the more we engage, and the more we practice what we preach, which is defending the Constitution, the better we all will be.
Well, so I want to thank both of our panelists, Mr. Ballo and Mr. Laurel, for your time and your insights today. We clearly didn't have very much to talk about on this subject, so I appreciate your thoughts and insights, and everybody's attention and commitment to a well-rounded discussion on this issue. I think there's a lot more to delve into, I think, as we've seen. Again, please tune in for additional panels on our Theories of Presidential Power series that are coming up in the coming weeks. And I hope to see you all at the Executive Board Conference on May 7th. So thanks again to our panelists, and thanks again for your time and attention.
Thank you.
I'll echo those thanks. Thank you so much to our panel for joining and participating. It was a wide-ranging and lively discussion, and we really appreciate you carving out this section of your days and sharing your expertise and insight. Thank you also to our audience for joining and participating. We welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.